Hello and welcome to the Rogers Brief for November 23rd, 2024. I'm Adam Rogers. Thank you for watching and thank you for listening. Today I've got a selection of cases and stories, some that are local to Nova Scotia, which I'm going to cover first, and then there's a few national stories, and then finally some international stories. On the international story front, there's the after following the election in the United States, some treatment of the various cases being faced by now President-elect Trump. Talk about those, what's going to happen with those. The International Criminal Court has issued an arrest warrant regarding Israeli Prime Minister Benjamin Netanyahu, and governments, including ours in Canada, have been asked what they would do if Prime Minister Netanyahu were to be on Canadian soil or whatever soil the leader was on. So we'll talk about that and the effects and reverberations there. And then an interesting piece of legislation coming out of Australia on young people and social media, access to social media. The national stories involve a few different things. The Paul Bernardo situation, parole board controversy that crept up this week, and the Pat King convictions. This is from the trucker convoy, the Freedom Convoy, the Ottawa occupation, however you wish to define it. So those there was a decision this week on his case. So I'll talk about that a little bit as well. And then locally, Nova Scotia. Well, there's some national implications to this. The first one I want to talk about in detail is this electoral boundaries decision that came down just a couple of days ago from the federal court, Justice Julie Blackhawk, and this now I think closes the book on the controversy is maybe putting it even too strongly. The efforts, at least by a member of Parliament Jaime Battiste and the First Nation of Eskasoni, to have the boundaries from the Electoral Boundaries Commission altered. So there was an appeal to the federal court, and that decision was released 2 days ago, and MP Jaime Battiste has made some comments on that as well. So I want to talk about that. That's going to be the first case I discuss, and then I'll probably get to that in some length. The other one's from Nova Scotia. The youth that was pled guilty to stabbing the vice principal and an administrative assistant at the high school in Halifax, Bedford, he was sentenced, and that decision, the sentencing decision, was released this week. Sentencing took place a little while ago, but the decision just released. So I wanted to look at that because, as you may recall, regular listeners, or if you watch the news on that story, members, the victims and members of the family walked out of that sentencing decision, which is a very unusual thing to see happen. So we'll talk about the justification, if any, for that reaction to the sentence. And there's another case, actually two other cases from Nova Scotia. One is this, just an update on the Tatamagouche teacher, Nicole McLeod, who was charged with sexual offenses against two male students in her school. And as well, there was a case from Nova Scotia that was decided by the Supreme Court of Canada this week. And this was a case that involved some, interesting legal argument. The case itself involved trafficking of an individual by her husband. It looked like her partner, at least. And so on November 15th, I guess it was a little more than a week ago. Oh no, not quite. Anyway, the Supreme Court of Canada released their decision on that, and talk about that as well, and some of the implications there. Not always that case out of Nova Scotia gets up to the Supreme Court, and this is, I think, will be seen as a significant decision. So I want to start, though, with the electoral boundaries case. And this was an appeal of the decision from the Nova Scotia Electoral Boundaries Commission, and that commission was chaired by Court of Appeal Justice Cindy Bourgeois. And I spoke about that decision at the time because it was a very thorough decision, something you would expect from a chair who was also happened to be a Court of Appeal justice. And in Justice Bourgeois' decision, the decision from the commission, it really, it was a thorough evisceration of each of the arguments that were put forth by Jaime Battiste. Jaime Battiste being the MP, but also law school graduate, who graduated together, we were classmates, and he has been involved in teaching and involved in indigenous legal circles in terms of his career following law school and before he was elected. But each one of his arguments were dismissed by Justice Bourgeois in a very thorough manner, and she went through like the significant Supreme Court of Canada decisions dealing with Aboriginal rights, procedural rights, consultation, rights to be consulted, some of the treaties that Jaime Battiste alleged were relevant. But while Jaime Battiste himself did not make this appeal, the appeal was actually made to the federal court by the First Nation of Eskasoni, led by Chief Leroy Denny, who is a friend of Jaime Battiste, and Jaime Battiste lives in Eskasoni, in the community. Represents currently the riding of Sydney-Victoria. Sydney, the old city of Sydney, plus the rural Victoria County is the current configuration. That's going to change, so in Cape Breton now there'll be two ridings, which there is now as well, but one more urban centered, which would include Sydney and Glace Bay and some of the surrounding communities, and the other including Victoria County, Richmond County, Inverness County, parts of CBRM on the eastern side there by like Lewisburg and such, and then parts of the mainland as well. So there'll be a rural riding and an urban riding. And so Eskasoni had been part of Sydney Victoria. Now it is going to be part of the larger rural riding. And so there were arguments about that because many people from Eskasoni do business and work in Sydney, and so the community of interest allegations and all these sorts of things. Well, the appeal went to the Federal Court of Appeal, and it was heard by Justice Julie Blackhawk, who was and is still an expert on Indigenous law. She worked in Indigenous law roles prior to becoming a judge of the federal court, and she herself is a Mohawk. She's from a Mohawk nation. So the decision from Justice Blackhawk was very supportive of the analysis done by Justice Bourgeois on the issues of Aboriginal rights. Said explicitly that Justice Bourgeois, or that the Electoral Boundaries Commission, correctly identified the cases that were relevant and the various, the relevant points of law that each of those cases held and represented. Each and every ground of this appeal was rejected. The court did not accept one single argument made by Eskasoni. And so I have a lot of questions about this. I'll come back to the actual legal arguments themselves, but this can only be seen as a disaster and a huge waste of money and resources by Eskasoni for no real purpose. There was no, if anybody who read Justice Bourgeois' decision would have said, well, that's the final answer. There's no appeal to that decision. It was just, point after point, everything that Jaime Battiste raised in terms of representation was rejected. And the federal court accepts that and supports that stance. How much money did the community of Eskasoni spend hiring a big Ottawa firm, Gallings, national firm, but based out of Ottawa? Elisa Tompkins was the lead lawyer. I see I think Keith Brown from CBU was involved as well. I'm just going to, before I get into the decision, I just want to read you the final paragraph of the decision, because this, I mean, it's a final paragraph. It encapsulates what took place. So Justice Blackhawk says this, paragraph 143 of the decision: I appreciate that Eskasoni is not happy with the decision and that they are no longer represented by their fellow community member, the first Mi'kmaq MP in Canadian history. However, the Section 3 Charter guarantee is a right to participate in a process, not a right to a particular outcome or representative. I am concerned that the issues raised by the applicants, which appear to be concerned with the outcome and the loss of MP Battiste as their representative, risk veering into the realm of gerrymandering. Gerrymandering. There you go. That's the term. I mean, that's quite an allegation, really, coming from the justice, who's heard all the arguments and understood what positions the parties were taking. Gerrymandering, of course, being a big phenomenon in the United States, where congressional seats are gerrymandered and adapted to get very specific voter blocks into very specific ridings and districts, and to ensure that whichever party holds the seat continues to do it by way of manipulation of boundaries and such. So that's what the court is alleging Eskasoni, Chief Leroy Denny, Jaime Battiste were all attempting to do here. So some of the arguments: the process, no consultation. There were 9 sessions held across the province by the Electoral Boundaries Commission, 8 in person, 1 virtual, and none of those were held in Eskasoni. And so there's no consultation, they argue. Well, the court says the Electoral Boundaries Commission is not the government, so there is no automatic, there's no, it's not the same framework or the same kind of analysis when you talk about consultation. Plus, and this was a point repeated a few times, and also by Justice Bourgeois, the MP himself, okay, so say part of the argument from Eskasoni was it's hard for them to get into Sydney. Well, it's not. It's only it's a short drive away. But even so, Wagmatcook's a little further away. That was one of the other arguments. It'd take about an hour to get from Wagmatcook. I think about 20 minutes to get from Eskasoni, and 5 minutes from Member 2. Yet, neither the Member of Parliament himself, nor the Chief, nor any others participated in any of those sessions, even when it was clear that there was a possibility of a boundary change. And even so, even if there wasn't, they said, well, if you feel so strongly about this, you could have gone to the session in Sydney, you could have attended the virtual session, you could have filed something with the Electoral Boundaries Commission. You did none of these things, and so how can you now say that you didn't have the right to participate? Yes, maybe it's difficult for some people with fewer resources within the community to get to Sydney and participate, but that doesn't give any excuse for why the Member of Parliament himself, the Chief, or others didn't take the opportunity to participate. The other thing the applicants raised, Eskasoni raised, was a failure to consider the Elikquake Compact, Elikewake Compact, which is a conglomeration of treaties signed between 1630 and 1779. Okay, but the court says Eskasoni did not highlight any specific promises, oral or written, in the various treaties that are relevant or support the asserted right. So, all right, we've got all, so this was something that Jaime Battiste was doing in his presentations earlier. It's like, oh, there's these treaties and these cases and these things. Okay, what specifically would affect the right to be consulted on electoral boundaries, on federal electoral boundaries? Is there anything in there? And there's another specific framework that was established by the Supreme Court of Canada in the case of Vanderpeet, a framework says that if you are saying that an activity has, there's some right for consultation, or an indigenous right that is relevant, then that activity must be an element of a practice, custom, or tradition that is integral to the distinctive culture of the Aboriginal group claiming the right. And there's an additional element that it has to have existed either prior to the treaties being signed, prior to that, and then, that or some version of the practice continues to the current day. Well, there was nothing about electoral boundaries that was part of the culture, or certainly integral to the culture. Court says band members can still vote. And by the way, the new riding, the rural riding, actually has a greater percentage of indigenous persons in it than the former riding. And so the argument that the Mi'kmaq vote is going to be diluted in the riding is simply inaccurate from a numbers perspective. So quite a decision. Really went under the radar. Nobody, I don't think, was reporting that the decision was forthcoming. Maybe they wouldn't know. They don't always announce these things in advance. The decision came out. It was an article in CBC, but the only reason the article came out in CBC was that the Member of Parliament himself, Jaime Battiste, issued a press release, a little one-pager, and he takes no blame for the decision. He says, I was informed that the decision came down. Of course, he would have known about it intimately. He would have been involved in the formation of it and advocating that Eskasoni carry the ball and pay for the litigation. The key, though, okay, what's he going to do? All right, not going to do a further appeal. No point of that, of course. No point in this appeal either. He says he fully expects to run. Fully expects, it's an interesting term, to run in the urban riding, Sydney-Glace Bay, even though he doesn't live there. And he talks about a clause in the Liberal Party constitution or documents that says if there's changes to the boundaries, but your riding still has 70% of the people that were in the previous riding, that there's that you're automatically in, and whatever benefits of incumbency are involved in those nominations continues. Okay, so but he doesn't suggest, he doesn't do the numbers. He says, he kind of plays around with the numbers and suggests that he should be automatic, but that not how I read the situation. Still could be a competitive nomination for the Liberal nomination in Sydney-Glace Bay. There's no comment anywhere in the article, in the newspaper, in the CBC article, or on his own Facebook page from fellow Liberal MP Mike Kelloway, to say, who's currently the Cape Breton Canso MP, to say what he's going to do. A lot of people suspect he was interested in running in Sydney-Glace Bay. Well, if he was going to do that, he should have probably announced it before Jaime, because now he's either going to be openly competing with Jaime Battiste, or he's going to have to run in the bigger rural riding. I suspect that's what he's going to end up doing, but you never know. Hearing some things that there's no love lost between the two Liberal MPs, so we'll see what that amounts to. Okay, so we'll watch for that. We'll see what happens in the nomination, but now that is a certainty as far as the next federal election, whenever that may be. It could be in the next few months or next fall. We just don't know yet. But whoever, we now at least know for sure what the boundaries are going to be. Although I would have argued, and I think I have argued here and other places, that we, based on Justice Bourgeois' decision, already knew that. Okay. Let's move on from that to some other stories. I'm going to go a little faster through the rest of the stories just to make sure I cover off some things. So, next thing is the Supreme Court of Canada decision. And this was a Nova Scotia case. Justice Cody was the original trial judge, acquitted a person of trafficking his partner, his spouse. There was the facts were that they had money trouble, moved out west. He made her sign up for OnlyFans. She did in-person sexual performances, I guess you'd say, and did some stripping, all under threat from her partner. And so he was charged with trafficking in persons. In the trial, there was evidence from her family members noting the evidence of violence in the relationship. But these witnesses couldn't testify to the evidence, the findings on the actual trafficking side. Now, the complainant herself gave that evidence, but there were some issues with her credibility, and so Justice Cody acquitted the man, and that the Crown appealed that. Court of Appeal in Nova Scotia upheld the acquittal, went to the Supreme Court of Canada. The issue is this: the evidence of past violence and a violent relationship. Normally, that would be inadmissible evidence because it is quote unquote past discreditable conduct. All right, you can't just come into court and say everything bad about a person and hope the judge says, well, seemed like a bad person, I'm going to convict them of this crime and they must have been more likely to have committed this because they're a bad person. You can't, that's inadmissible evidence. Now, actually, the trial judge did admit the evidence, but the Supreme Court of Canada said he mischaracterized it and didn't include it as direct evidence of the trafficking. Supreme Court says that is evidence of trafficking because you create an atmosphere of fear, and that kind of atmosphere can compel somebody to do things they wouldn't otherwise want to do. So it is relevant to the core issues. So Mark Scott and Glenn Hubbard for the Crown on that, David Mahody and Michelle James for the defense. Sounded like a well-argued case on both sides, but that's ultimately led to the acquittal being set aside, which the Supreme Court of Canada says they do not do lightly, and a new trial is going to be ordered. So we'll see what the Crown does with that if they continue the prosecution. Next story. Tatamagouche teacher Nicole McLeod has new breach allegations. This is the second time now, accused of sexual misconduct with two male students. Had allegedly breached those conditions back in the summer, led to strict conditions under surety, now has allegedly breached them again. She's been ordered not to have a smartphone. She can have a flip phone only and has to present that to the police to prove that it doesn't have any capabilities beyond an old flip phone's capabilities. And she's now not living with her father, but living with her mother. They're separated and in a new situation. So 24-hour house arrest, I think, with just a few exceptions to get out. Of course, non-contact with the victims continues, or alleged with the complainants, alleged victims. Next case is the just a note on the decision that came out in the school stabbing. Now, this was a decision of Judge Elizabeth Buckle, top judge on the court in Nova Scotia. Terry Nickerson was for the Crown, Paul Shepard and Anna Mancini from Legal Aid for the defense. Crown was seeking 12 months in jail, followed by 12 months of conditions for the youth. And the defense was looking for a conditional discharge. It was pretty aggressive recommendations on both sides. This seemed like it was probably too much of an incident, too serious of a charge for a conditional discharge. However, the young person has, according to the decision, been doing quite well in the, I think 16 months, I think, since the incident up to the decision on sentence. Has been following conditions, has been, doing well in rehabilitating himself. Has medication has been adjusted, and has been complying with everything. Has not gotten into any trouble whatsoever. The judge noted a few times that the Crown exaggerated the beyond what was in the evidence, saying that the vice principal almost died. There was no evidence of that. Of course, he was injured badly, but did not almost die. There's no medical evidence to support that. And the young person was under a lot of pressure and didn't have any, wasn't a person that came from poverty or difficult home life really, although his parents were divorced. Seemed like just a high pressure situation. He was an international baccalaureate student, had some high achieving athletic either results or wishes, because he was training for something. The decision was very vague on these things, not wanting to identify the young person, but it sounded like he was training for some elite sports competition and was under a lot of pressure there, but also was on the internet and going to dark sites and seeing a lot of negativity online, so was being affected by that. So the judge gave probation for 2 years with conditions, and so rehabilitative focus because it's a young person. So that seemed like a fair decision, and completely offside, I would say, for the people to be walking out on that, victims walking out of the courtroom on that. All right, so there's Nova Scotia. I'll zip through the Canadian cases. I just want to mention a few of these actually, because the Pat King convoy conviction came down just yesterday. The actual decision is not out yet, the written explanation as to why. Because so Pat King, one of the purported convoy leaders, one of the people that was prominent spokesperson certainly among whoever was speaking for the group, such as it was, convicted of mischief, counseling mischief, that's damage to property, disobeying a court order, and I think that would be the injunction against noises beyond a certain time of night. But again, even that wasn't really explicitly laid out in the articles that we can see. Lots of media covered this, but they didn't cover it in great detail. So I want to review this decision when it's released to see whether an appeal is likely to be successful. I think an appeal is likely to be filed. Certainly on the how the judge characterizes the mischief will be very interesting to read, because the mischief in some ways was blocking highways, blocking roads, while the police were in some ways just as responsible for that problem as the truckers. And the question as to whether Pat King was directing specific truckers to specific spots and these sort of things, that'll be interesting to review in detail. Okay, so I'll wait for that. Paul Bernardo, that was a situation, this parole board hearing, and it was very bizarre because the victims and victims' families make comments at these parole board hearings, and it's just awful that they have to keep coming back every couple of years. Paul Bernardo was moved from Ontario to Quebec, so it's a little bit of a travel for them. But their lawyer, the family's lawyer, was told that the families can't show up to the parole board hearing. Well, the only reason to keep families away from a parole board hearing is whether there's a safety concern for anybody involved. Well, there was nothing, according to their lawyer, the family's lawyer, nothing specific that the parole board identified in terms of a safety concern, and they just, as soon as there was any public pressure, they just reversed the decision, and so we'll never know what the allegation was. Very curious. Seems like a situation where they may have been considering parole and just didn't want, maybe they thought the chance of parole is more likely, and they don't want the family there reacting to that, which would be terrible news for a lot of people. Okay, so let's go international. We've got a couple of minutes to get through this now. I'll get international news. Australia has instituted a ban on anybody under 16 years of age joining social media. Now, this was kind of interesting in a few ways. First of all, the onus is going to be on the companies. The companies have to develop protocols and structures, age verification software and that to make sure. It was announced by Australia's communications minister, not the justice minister, so I thought that was interesting. Communications being communication systems, I guess, and not not something else. Concern by opponents that this will just drive people under 16 to go to covert and unregulated spaces. Well, we'll see. That's maybe easier said than done. I mean, if you want to be on certain platforms and those platforms are regulated, yes, I guess you could go on to other platforms, but those are usually quickly identified as well as soon as they become popular, like all the Twitter/X replacements that are trying to establish themselves now. All right, so that's happening in Australia. Happening in various places now is the discussion about the International Criminal Court's arrest warrant for Benjamin Netanyahu. So the International Criminal Court, those that wouldn't be aware, is based on it's not that old. It's only been around since 2002. Set up seemingly, one would say, maybe cynically, for European powers to prosecute African warlords and despots and genocidal situations out of like Rwanda and such. But now it's being used to issue an arrest warrant against Benjamin Netanyahu, the Prime Minister of Israel, and his defense minister, former defense minister now. 124 countries have signed on to the Rome Statute, not the United States. So that tells you, in some ways, all you need to know about the International Criminal Court and its potential reach. I mean, no American, the Americans just wouldn't sanction any international body investigating or potentially prosecuting a government official, somebody in the military of the United States. They just wouldn't. They just won't stand for it. And they're not going to stand for anybody trying to arrest Benjamin Netanyahu either. As soon as Canada, through the Prime Minister, announced that, well, we're part of the International Criminal Court and we'll uphold our duties under that. Senator Lindsey Graham from South or North Carolina announced or said that if Canada did that he would immediately prepare sanctions against the country and enact those. So I think we need to be very careful about that and maybe re-evaluate our commitment to this International Criminal Court in its current structure. All right, last thing. Donald Trump's criminal litigation matters. What's left? Not much. So the Georgia case where he allegedly asked an election official to find him some votes, quote unquote, that's already been dismissed. A lot of it followed the Supreme Court of the United States' decision, which of course has been inflamed beyond what it actually said by those on the left especially, saying that a president cannot be prosecuted for criminal acts, or for certain things as criminal acts, if they are done in the course of their presidential duties. So the Georgia case where the president at the time was talking about the votes and all these things, that was covered and that was not. So my interpretation of the Supreme Court's decision is if the president did punched somebody or killed somebody in their personal life or committed theft in their personal life somehow, well, that would be a criminal charge that would be sustained. But if it's anything to do with their duties as president, it will not. So the election thing in Georgia, that was already dismissed on that basis. The federal cases on the election interference, the January 6th stuff that Special Prosecutor Jack Smith was prosecuting, he has asked for those. He's already asked for those now to be stayed, and he will not. He's not going to, pursue anything. A president cannot be prosecuted while in office. So the last one is this hush money, the Stormy Daniels case that Judge Juan Merchan was presiding over in New York, and so Trump was actually convicted there and was ready for sentencing. Well, the question is now whether to adjourn that sentencing hearing until after he serves his 4 years or dismiss it. It looks like the Trump team has asked for it to be dismissed. I think it will be. I think it seems inconceivable that a president will be serving 4 years as president with a criminal sentencing sort of hanging over their head the entire time. there's a rule you can't prosecute a president while he's a president. So to have that sitting, and I think, and a sentencing is part of a prosecution. So I would think that this is going to be dismissed. We'll wait to hear that. It'll be done certainly before the inauguration on January 20th. So anyway, lots going on this week. It's a little longer. I usually try to keep it to 30 minutes. It's about a little over 35 now. But that I'll make up for it by we're not appearing tomorrow night on the Sunday night Canadian Crime Weekly show. That is off for this week. The host, Jordan Bonaparte, had some other commitments, so we won't be talking about that. But there's lots of stories out there. I know Paul Palango has been sending lots of stories around to the two of us to review, and I was excited for the show, but we'll cover some of that stuff next week. So anyway, that's that for this week. I want to thank everybody for watching, and thank you for listening, and we'll see you next time.